Organizing your business as a limited liability company, or LLC, has many advantages. It's simple to set up, there are tax benefits, and perhaps best of all, an LLC can shield your personal assets, such as your home and car, from business liabilities. We'll show you why that is and how you can make sure that that protection is maintained. But first, some background to answer the question. What exactly is a limited liability company, or LLC? What is an LLC? The LLC, as a legal way of organizing a business, was created to gain the advantages and avoid the drawbacks of two tried and tested business models, that is, partnerships and corporations. Partnerships face only one level of taxation, which is good, but owners, or partners, have unlimited liability. They can be on the hook for any amount of debt run up by the business, which they would have to satisfy from their personal assets. Corporations are different. Their owners, or shareholders, have limited liability. This means their liability is limited to the amount they have invested in the business. The downside is that there are two levels of taxation. Both the corporation and the shareholder are taxed. The LLC is designed to provide the best of both worlds. It has limited liability, like a corporation, but is taxed at the owner level, like a partnership. An LLC also has other features that make it ideal for small businesses. The requirements for legally operating an LLC are minimal, and it is a distinct legal entity. We'll see why that helps protect your personal assets from business-related liabilities. Here's how an LLC protects you. Your LLC is a separate and distinct legal entity. One of the most significant benefits of an LLC stems from the actuality that when one is formed, an entirely new legal person is created. This makes the LLC a separate and distinct legal entity from its owners, also known as members. This legal separation offers several advantages to members, making it a popular choice for business entities. This separate legal status is important because it means that the LLC itself can enter into contracts, buy, sell, and own assets, and take on liabilities and credit in its own name. The LLC can also hire and fire employees. In certain circumstances, the LLC can even hire you as an employee, although generally, members of an LLC are regarded by the IRS as being self-employed. An important advantage of the LLC's separate legal entity status is the protection it provides to owners' personal assets. If an LLC enters into a contract where it borrows money or takes goods on credit, the creditor, that is the lender or vendor, won't be able to go after owners' personal assets to satisfy the debt. This means that your home, car, and personal bank accounts will generally be safe from these business-related claims. You can enjoy this restriction on your personal liability because the law recognizes that you and your LLC are two entirely separate persons. So if the LLC borrows money or buys goods or services on credit, it's the LLC that has to pay the creditor. An LLC's debts are its own liabilities. The flip side to this arrangement is that you will not own the business assets. That truck or car, those computers, the furniture in the office, all of that belongs to the LLC, not you. What you do own is a share in the LLC, which is referred to as a membership interest. In other words, the LLC owns the assets and you own the LLC. What is limited liability? Limited liability is a legal principle that means an individual or organization is only liable for the amount of money they have invested in a business or venture. The limited liability of your LLC provides another layer of protection for your personal assets, particularly if things don't work out as planned. Having limited liability protection may seem unnecessary because, as we discussed a while ago, you are not personally responsible for the debts of the LLC. But an LLC can have other obligations to pay money. For example, it can owe taxes or have to pay a court judgment. These are not obligations that the LLC consensually entered into. There was no contract where the LLC got something and now has to pay for it. These are obligations imposed by law. Limited liability means an owner would have no duty to honor those kinds of obligations if it meant contributing more money than he or she originally invested. If the LLC runs short of cash for whatever reason, a member has no legal obligation to provide additional funds. Limited liability really takes effect and becomes important if a business becomes insolvent, because that's the time creditors usually expect the owners to pick up the tab. However, the term limited liability has become a catch-all phrase for the protection that members of LLCs and shareholders in corporations enjoy from claims made by third parties, particularly trade creditors, since both the LLC's separate legal status and an owner's limited liability generally have the same effect. That is, protecting the owner's personal assets from business-related claims. However, Used in its traditional sense, the concept of limited liability really only means the liability of a member is limited to the amount they have invested in the LLC. Piercing the corporate veil. While in general, the separate legal personality of your LLC will shield your personal assets from business claims, there are exceptions to this general rule. In certain instances, the courts may allow a claimant to disregard the separate legal status of your LLC and hold owners responsible for the LLC's liabilities. This is known as piercing the corporate veil. The veil being the separate legal personality of the LLC. Here are the three main ways the courts will allow a claimant to pierce the corporate veil. Engaging in fraud. In the past, courts have pierced the veil to hold the owner responsible if the owner does anything that's dodgy. For example, an owner may transfer assets from one entity against which a judgment has been issued to another entity to avoid paying up. Personal guarantee. The corporate veil may be pierced also if you give your consent. It may seem strange that you would permit your limited liability status to be ignored, but this is what you do, albeit indirectly, when you sign a personal guarantee for a business. The guarantee allows a lender or other creditor to hit you up if your business can't pay. Failure to maintain separate identities. Another way to blow the cover of your protection is by failing to maintain the separate identity of your LLC. This can happen when you treat the business assets as if they're your own, because remember, they're not. Or if you mix business and personal transactions and assets, which is known as commingling. Then it becomes difficult or even impossible to know where your personal affairs end and your business activities begin. In such a case, a court is likely to assume the LLC is simply your alter ego, that is, simply you acting in another guise. One sure way to avoid allegations of commingling is to have separate bank accounts for your LLC and for your personal affairs. And of course, any transactions pertaining to the business should go through the LLC account. The same applies to payment methods, such as credit cards, charge cards, and the like. A business card is only for business. What an LLC won't protect you against. Apart from the unhappy scenarios where the corporate veil of your LLC might be pierced, there are situations where you may find yourself personally liable even though your LLC's corporate veil remains. Signing in your personal capacity. This situation typically arises because you sign in your personal capacity when you thought you were signing on behalf of the LLC. To avoid such a problem when signing, make it clear you are signing on behalf of the LLC. Write your full name, your position, include words that show you are signing for the LLC, and sign just above your name. You should end up with something like Tom Brown, managing member for Tom Brown Consulting, LLC. Also, to make it clear that not every document you sign is in your personal capacity, the operating agreement should state your position and that you have signing authority for the LLC. Negligence. The limited liability protection provided by your LLC does not apply where you personally do something negligently in the course of business which causes injury to someone. For example, you hire an electrician or plumber who is not licensed without carrying out a proper background check. Or you may have failed to remove a damaged chair which later collapses, causing a customer injury when he or she sits on it. In these instances, you would be personally liable if it had been your personal responsibility or duty to perform the background check or to ensure customer safety. The term injury is wide. It can cover physical injury as well as damage to property or reputation, although in general, it does not cover pure monetary loss. Organizing a business as a limited liability company offers numerous benefits, with one of the most significant advantages being the protection it provides to an owner's personal assets from legal claims. This protection is often referred to as the limited liability shield, and it is a key reason why many entrepreneurs and small business owners choose to structure their companies as LLCs. For more information on LLCs, how they protect you, and how to form one, check out our pages at howtostartanllc.com, linked in the description below. You'll find lots of guides and advice that will help you kickstart your business journey. Additionally, we have all sorts of free tools and resources to help you as an entrepreneur or small business owner. And if you have any questions at all, hit us up.